Former President Trump has been ordered to answer questions under oath as part of a fraud investigation into his company. A New York judge ruled yesterday that the former president, Ivanka Trump, and Donald Trump Jr. must obey the subpoena from New York Attorney General Letitia James. She is considering a lawsuit against the Trump Organization, one of several legal challenges to the former president. Senior investigative correspondent Catherine Herridge is following this probe. Catherine, good morning.
Well, good morning, Nate. The judge's order opens the door to depositions by former President Trump and his two eldest children within 21 days. If it's upheld, the 8-page ruling means New York State Attorney General Letitia James could ask Trump, Ivanka, and Don Jr. about their business practices as part of a civil probe. James has accused the Trump Organization of using fraudulent or misleading practices to get loans and tax benefits.
At 4:59 p.m., the clock was no longer measuring time. It was measuring defiance. A federal judge had ordered a sitting president to testify under oath about alleged financial misconduct. And instead of walking into that courtroom, he walked into confrontation. Not negotiation, not delay, confrontation. His legal team filed a blunt refusal, arguing immunity, invoking executive privilege, daring the judiciary to push back. That single act reframed the moment. This was no longer about documents or bank transfers. It was about whether a president can look at a lawful court order and simply say no. And here is the destabilizing truth. When a court compels testimony under oath, it is not a suggestion. It is the enforcement arm of constitutional structure. Sworn testimony is the mechanism by which the judiciary extracts truth. Refusal is not symbolic. It is contempt. The judge did not request casual conversation. He demanded sworn answers under penalty of perjury. If the president lies, it is a felony. If he tells the truth and that truth implicates him, the consequences expand. That is the trap. And instead of stepping into it, he challenged the trap itself. This is where the stakes escalate. Executive privilege shields confidential communications tied to official duties. It does not shield personal financial behavior. It does not erase allegations of asset concealment. It does not suspend judicial authority in civil fraud proceedings. Yet his lawyers argued precisely that the office itself creates insulation from compelled testimony. If that argument stands, the presidency becomes a legal sanctuary. If it fails, the refusal becomes defiance of a direct court order. Either path carries systemic consequences. The allegations are not cosmetic. Prosecutors assert that assets were moved, funds transferred, structures rearranged to protect wealth from judicial reach. Offshore jurisdictions, rapid reallocation, financial opacity. These are not abstract accusations. They are traceable transactions. That is why the judge demanded testimony, not headlines, not press conferences. Testimony under oath. Because sworn answers collapse ambiguity, and ambiguity in financial fraud investigations is oxygen. Remove it, and the exposure accelerates. Now consider the leverage point. The court-attached enforcement, $50,000 per day for noncompliance. Daily, compounding. That is not theatrical. That is coercive architecture. Contempt fines are designed to pressure obedience, not punish retroactively. But the judge did not stop at fines. He signaled incarceration as a possibility, jail for contempt, a sitting president facing confinement for refusing to testify. That is not a hypothetical from a law school exam. That is a live constitutional stress test. This is the pattern recognition moment. Throughout modern history, executives have negotiated with courts. They have appealed. They have delayed. They have argued scope. What they have not done is openly reject judicial authority in real time. This refusal mirrors a broader authoritarian playbook. Contest the legitimacy of oversight institutions. Claim persecution. Redefine accountability as political attack. Once that narrative takes root, compliance becomes optional. And when compliance becomes optional for the executive, separation of powers begins to erode. Because this is not merely about financial disclosure. It is about structural hierarchy. Article 3 courts derive authority from the Constitution itself. Their orders bind citizens and officials alike. If the executive branch asserts unilateral immunity from judicial compulsion in matters unrelated to core national security, it redraws the constitutional map, quietly, incrementally, and if no boundary is enforced, the precedent metastasizes. Today, it is financial testimony. Tomorrow, it is criminal subpoenas. The slope is not theoretical, it is historical. Translate that into real-world consequence. If contempt fines accumulate and remain unpaid, the court escalates enforcement. If enforcement escalates and is resisted, the crisis deepens. At some point, federal marshals execute judicial directives. Imagine that collision. Law enforcement officers enforcing a judge's order against a president who claims immunity. That is not partisan drama. That is institutional collision. And institutional collisions do not resolve quietly. There is another layer here, one that sharpens the tension. Sworn testimony carries a binary risk structure. Answer falsely, and perjury exposure emerges. Answer truthfully, and admissions may fortify fraud claims. The Fifth Amendment exists, but invoking it in a civil fraud context carries reputational and legal inferences. Every path narrows. That narrowing explains the refusal. It is not bravado. It is strategic avoidance of a lose-lose oath scenario, and that avoidance itself now triggers a separate legal hazard. Look at the cascading pressures surrounding this moment. Parallel investigations, declining political capital, allies reconsidering proximity. Each external stressor amplifies the stakes of courtroom confrontation. When political insulation weakens, legal vulnerability intensifies. That convergence is what makes this refusal different from past defiance. The margin for maneuver is thinner, the optics harsher, the institutional patience shorter. And here is the constitutional hinge. If a president can ignore a judicial order without immediate consequence, the judiciary's coercive power weakens. If the judiciary cannot enforce its orders against the executive, it becomes advisory. Advisory courts do not uphold rule of law. They offer commentary. The framers did not design commentary. They designed checks. Checks require enforcement. Enforcement requires compliance. Break that chain, and the architecture strains. Some will frame this as political warfare. That framing misses the structural question. Courts compel testimony every day. Governors comply. Cabinet officials comply. Corporate executives comply. The presidency is powerful, but it is not a parallel sovereignty. Immunity doctrines are narrow for a reason. Expand them beyond core executive function, and accountability dissolves. That dissolution is not loud. It is procedural, which makes it more dangerous. Now escalate the lens further. Imagine the precedent crystallized. A future executive cites this refusal to dodge inquiry into personal enrichment, campaign finance irregularities, obstruction allegations. Each citation builds on the last. Institutional memory hardens around the idea that the Oval Office confers testimonial immunity. That is how erosion works, not in a single explosion, but through accumulated allowances. If incarceration were ever imposed for contempt, the shockwaves would be immediate. Questions of succession, questions of capacity, questions under the 25th Amendment, Congress forced into accelerated decision-making, markets reacting, international observers recalibrating assessments of American stability. The ripple effects would extend beyond one courtroom. They would test the resilience of constitutional continuity. So this is not spectacle. It is stress fracture analysis. A judge ordered sworn testimony in a fraud investigation. The president refused. Fines accrue. Jail is signaled. Immunity is asserted. The judiciary stands at one boundary, the executive at another. Between them sits the Constitution, waiting to see which clause holds. The answer will not be delivered in rhetoric. It will be delivered in enforcement, because the ultimate question is brutally simple. Does the rule of law bind the presidency, or does the presidency bend the rule of law? That question is no longer abstract. It is procedural, financial, and potentially carceral. History does not pivot only on elections. It pivots on compliance with lawful orders. Watch this moment closely. Institutional decay rarely announces itself. It reveals itself in refusals.